This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about appraisal and why appraisals and appraisers are not allowed to determine causation, at least in the state of Mississippi, and that appraisal is limited to determining the quantum of a crop loss when dealing with a crop insurance policy. In a case called Agrisompo North America, Inc. versus Coldwater Planting Company et al., a November 4, 2022 decision of the United States District Court for the Northern District of Mississippi, Coldwater Planting Company et al. Moved to dismiss the action. Plaintiff Agrisompo asked the USDC to enter an order appointing an umpire to decide the underlying crop insurance dispute. The dispute in the case is to determine whether the crop damage suffered by the insureds in June of 2021 was caused by a covered wind damage event or a non-covered flood event. The parties were unable to resolve their disagreements regarding this issue, and plaintiff responded to the impasse by suing to appoint an umpire for an appraisal process. The plaintiff contended that the court had the authority to make such an appointment based on an appraisal policy provision, which states that the appraisal procedure will be used, quote, if you and we fail to agree on the percentage of loss caused by one of the insured perils. The court noted that there is extensive Mississippi authority holding that under the law of Mississippi, an appraiser may not determine causation issues under an insurance contract. In Jefferson Davis County School District versus RSUI Indemnity, a February 11, 2009 decision of the Southern District of Mississippi, Judge Parker wrote, quote, defendant argues that appraisal is inappropriate because this case involves coverage and causation questions, not a dispute about the value of an admittedly covered loss. Judge Parker also wrote that it is clear that under Mississippi law, the purpose of an appraisal is not to determine the cause of loss or coverage under an insurance policy. Rather, it is limited to the function of determining the money value of the property at issue. This authority convinced the U.S. District Court judge as being directly on point to the issues raised by the plaintiff, and in response, plaintiff was only able to offer its precedent from other states, which follow a different interpretation of the law. While plaintiff is able to cite extensive authority from other jurisdictions in this regard, this merely served to highlight the fact that it is defendants who are able to offer Mississippi precedent on point. Plaintiff did not dispute that this diversity action is governed by Mississippi law, and it is therefore clear that the relief which it seeks from the court is unavailable to it. The court noted that a civil action is presently pending in the Greenville Division, which seeks to litigate the insurance coverage issues in this case, and it concluded that the case is the proper forum for the parties to resolve their coverage disputes in the Greenville Division litigation. The defendant's motion to dismiss the action was therefore granted. In my opinion, standard appraisal language limits the ability of the appraisers to only determine the amount of loss. Determination of coverage disputes can only be resolved in appropriate breach of contract actions. Although some jurisdictions have tried to give appraisers more authority than that provided by the policy wording, the United States District Court in Mississippi kept to the authority in the policy, and that followed by the courts of the state of Mississippi. This video was adapted from my blog, Zelma on Insurance, which is available to anyone who clicks on the URL zelma.com/blog. It is also available as a video on rumble.com and on youtube.com, and I would appreciate it if you would subscribe to the blog and to the videos. And if you watch this video on rumble.com, please click on the Rumble button. And if you watch the video on youtube.com, please click on the like button. Thank you for your attention.